Hey guys, thank you for tuning in today. Today we have with us Summer Reyes, a closing or real estate attorney, and we're going to be talking today a little bit about what it means to have a closing attorney. And she's going to go over some of the things with this, as far as what's important about having a closing attorney. Guys, bear with me for just a moment. I'm trying to set the screen up. But Summer, hey Summer, how are you?
Hi, I'm good. How are you doing today?
Good. Hey Summer, tell us a little bit about yourself, your company.
Yeah. So like you said, Summer Reyes with Holiday Ingram. So we are a real estate closing attorney. I have been in the real estate world for almost about 17 years now, which makes me feel old, but anyway. So been doing that. I trained in law school as a real estate paralegal and then joined into that after law school. So I love the real estate side of things. I've been doing it for a while. Was with my previous law firm for about 7 years and then opened up this location. We are based out of Greenville, and I opened up the Charleston location about a year and a half ago. We are in the Nexton area in Somerville, but do closings all over. We have space in Mount Pleasant. We do some travel closings. So we get to go around to everyone, and we're also opening up an office in Lexington too, so we're going to be all over the state here shortly. So things have been going really well. I'm also married, have 4 children, so they keep me running around going crazy, and especially during this day and age with school and everything, you know how that is.
Yeah, I do. Summer, we've been together for quite some time now. But
Yes.
Summer, tell us a little bit, or tell the those who are listening a little bit about what you do and why you get involved in real estate closings.
Yeah, definitely. So a lot of times, especially in Charleston, right, we have so many people that are moving from out of the area, out of the state. Especially right now, it seems like that is even ramped up even more. So a lot of times when you're coming to South Carolina, you're kind of confused about what an attorney is doing and why they're involved. In some states, it's because an attorney is not involved at all. In other states, an attorney is involved even more than we are here. So it really is determined by the state. In South Carolina, a real estate closing does have to be conducted by an attorney, or at least supervised by an attorney is how they nominate that. So
Mhm.
there's about 4 different pieces of the closing transaction that occurs that an attorney has to be responsible for. So that is our main role in it. So you as the agent, you're working with the client, getting them their contract, finding their property, getting the contract signed. Once the contract is signed, then that is when it comes to my office. I then work with the buyer and the seller, any other attorney involved, and the lender, and make sure that the closing and all the terms of the contract have now been met, and we get to the closing table. One of our big pieces that we do is the title search. And so, and this is where people will be familiar with this from other states, but a lot of times in other states, it's just the title company that handles all of that. In South Carolina, the attorney handles that, and we also represent the title company as well. So we do the title search. We review it. It's going to be anywhere from 40 to 60 years back in the chain of title. So we trace the ownership back that far to make sure that what you're buying is what you thought you were buying, right? And you're buying it from the right person. So we're going to find, if someone else had been on title with that person, you want to make sure you're buying it from John and Sally, not just John, if they both own the property. So we're going to look for things like that. We're going to make sure that the legal description, which is how your property is defined,
Mhm.
it's got to be clear enough to where someone can go out and find it and put their foot on that property. If they can't find it, probably about 15 to 20 years ago is when we really started using plats and surveys all the time. But before that, we used to just describe land by whatever was around it, right? So we would say
Mhm.
1 acre surrounded by John's property and Susie's property and Sally's property. Well, now those people don't own it
Right,
anymore. And there could be lots of 1 acres that fit in that description.
right.
So that's one of the things that we're checking, is to make sure that that legal description is accurate enough so that we can write you a title insurance policy that
Right.
protects that buyer against any future or previous issues. We look for liens on the property. So if there's mortgages on there, if there's judgments in South Carolina, one thing that sometimes catches people off guards are judgments. So any judgment doesn't have to have anything to do with your real estate. It could be a credit card judgment. It could be a judgment from a lawsuit, like if you got into a car accident and got sued.
Right.
Any judgment is going to attach to the property. So we're looking for those and making sure they get paid off so that when it does transfer to the buyer, you're transferring clean title ownership. You want to be able to, obviously you want to own 100% and have nobody else out there that has any partial, claim to that. So that's our main role, is the title portion of it, making sure that that is all clear and gone. And we have to certify that to your lender, and we certify that through issuing a title policy. So we issue that policy to the lender. We also issue one to the buyer that is kind of our guarantee, right? So if anything comes up that we missed or was forged or anything like that, this policy is going to protect you going forward.
Okay. How does that work with someone who may have purchased a property from a tax sale?
Yeah. So tax sales, okay. So in South Carolina, tax sales do not go through the court system. So if you're familiar with them, you've seen them, they just advertise that this sale is happening. You just go and buy it from the tax office, the assessor's office. There is automatically a year of redemption. So even if you buy it, let's say I bought property last November when they had their sale, I don't actually get ownership of it until this November, because that owner has a year, it's called a year of redemption, where basically they can bring their account current and still keep their property. If they don't do that, then this November or December, the tax assessor will issue a deed in my name. The problem with that is they don't do a title search. They don't serve people through the court system. So it's not like a lawsuit that's filed where you have to serve people with a service processor or through the paper for 3 weeks in a row or any of all of that stuff. So because it doesn't follow all those rules, I can then not issue title insurance because I have nothing to rely on that proves you notified all the people that needed to be notified. So there's a couple of ways you can fix that if you do have property from a tax sale. One, you can just not fix it and you can sell it. And there are some people that will buy it, but they're going to be only cash buyers because a lender is going to require that title policy that I can't issue. So you're going to be limited your pool. You can also do what's called a quiet title action, which is an actual lawsuit through the court system where you would name anybody that needs to be named. And then that would clear title essentially. At the end of the day, you would get an order from the judge that said, okay, Summer Reyes officially owns this property and all is good. And that's going to require all those notices to go out. So that's why that works. Sometimes if there's no mortgage or anything on the property, you can get a deed from the owner who lost the property, and that'll clear everything up. So that's obviously the cheapest route to go, but it doesn't always work. You don't always know them. Sometimes they passed away, so then that doesn't work. And so the last way to do it is to get a document. You have to get the information from the county as to how they filed notice, who they gave notice to, and if all the right boxes are checked, then sometimes you can still get a title policy issued. It kind of depends on what's happened there. So usually I tell people, if you're buying at a tax sale, just go ahead and plan on doing a quiet title action as well. That is going to take some time. It usually, right now, it's probably a lot longer than it used to be because of the COVID stuff and courts not being open. But usually I tell people it's going to take around 6 to 9 months. It's going to cost you anywhere from $5,000 to $10,000 to do that, depending on how many people have to be served. But if you bought it for a really good deal and it only cost you $5,000 to clean it up, it may still be a really good deal. You just kind of have to know all those things that you got to walk through.
Well, you checked off one of those questions I was just about to ask you as far as the cost and the duration. Summer, tell us a little bit about the fees that are associated with closing on a regular home loan.
Yeah, so if you're doing a regular purchase, and one thing to keep in mind is that the buyer and seller both have to have an attorney represent them.
Mhm.
Now, I'll say the majority of the time they choose the same attorney. The buyer chooses their attorney, and the seller often just says, well, I'll just use the same attorney because it makes things a little easier.
Right.
But they don't have to. Buyer and seller can choose their own attorney. Even if they choose the same attorney, there's still going to be fees that go to both parties. So for my firm, on the seller side, we charge a $395 attorney fee, and then a $75 fee for to cover like the payoff of their mortgage, to get the payoff, wire those, or overnight the proceeds, whichever route is needed there.
Mhm.
On the buyer side, we charge a $445 attorney fee. Then there is a title search fee of $225, usually $225 to $250. That comes from an abstractor, so sometimes that's a little higher than others depending on how complex the search is,
Right.
and how many copies and things like that. But usually in the $225 to $250 range. Then we also have a title commitment fee, which is $225. That is that fee to issue that title policy.
Mhm.
And then there is also a title insurance premium. So that is based on the purchase price and your loan amount. So that's going to be different, obviously, for each transaction. However, those premiums are set by the state. So I tell people, if you're shopping around or you're comparing prices, those are going to be the same regardless of who you go to, because they're set by the state. So my fee for the title insurance are going to be the same as the other attorney for that. So you really want to compare like your attorney fee, title search, title commitment. We do charge a $25 overnight fee for the loan package. So those kind of fees are what you're looking for there, and those are mine. So
Okay. How about the fees associated with filing the deeds?
the deeds, yeah. So in the standard contract, the seller is responsible for the recording fees of the deed, which in e-recording counties, which is Dorchester and Berkeley in the Tri-County area, that's $19.50. In Charleston County, they do not e-record, so it's only $15. And honestly, e-recording is the greatest thing ever. So we're all hoping that Charleston County gets that going here soon, and I know they're working on it. So those are the recording fees, and that is for the seller. The seller also traditionally pays what's called deed stamps or transfer taxes, and that is based on the purchase price as well. So it's a weird calculation. It's $1.85 per 500 of the sales price, and you always round up. So it's always weird, but most agents, I know when you're doing your net sheet, you're going to have that calculated in so you can give people an estimate of what that is. On the buyer side, the buyer is going to pay for the recording of their mortgage. So in a e-recording county, that's $29.50. In Charleston County, it's $25 flat. And we switched over to flat recording fees a couple of years ago, which is awesome. We used to do it by page number, which was kind of annoying because you have to count all the pages. Now it's just $15 for a deed, $25 for a mortgage. And then the $4.50 if you e-record is charged per document there. And keep in mind, if you have to do any power of attorneys or additional deeds, or if you own property in a trust, there usually is other documents that have to be recorded as well. So any additional documents will just be charged to whatever party needs it, and we would let you know that fee prior to closing.
Okay. What can a buyer expect as far as bringing to the closing table? The insurance, taxes, mortgage, first mortgage payment. What can they expect from that?
Yeah, so when you come to the closing table from our office, all the buyer has to bring is 2 forms of identity. One has to have your picture on it.
Mm-hmm.
Typically, the other one, we already have your insurance, but I always tell people to bring 2 just in case, because everybody's a little bit different on what the requirements are. At the table, you're going to bring your closing costs. So whatever it cost you, your down payment plus your closing costs. So depending on how your contract is written, how much you're putting down will determine how much you're doing there. You're going to get a loan estimate from your lender kind of early on that'll give you a rough guess of what that fee will be. And then we would nail down that number with you usually the day before closing. It is kind of last minute, and that usually throws people off. Because they get nervous, they want to know exactly what to bring, but it's just the way the numbers have to go back and forth and balance, and with the lender sending us stuff and us sending it back, it typically is not 100% final until the day before closing. Right. But you're going to get those estimates from the lender there on that. When you come to my office, we're going to bring in the lovely stack of paper for you to sign. 80% of it, the buyer has already seen. They've already signed it with their lender, usually electronically or in person, depending on
Mm-hmm.
which route you took. But we go over it all again, just make sure it's all still true, make sure all the numbers look right. Obviously, we want to really make sure your interest rate and your monthly payments are the same as what you thought they were going to be, right? We
Right.
don't want any surprises there. So
Mm-hmm.
that's what we're going to run over. We're going to sign all those documents again. You're going to bring that money. We accept checks or a wire for your closing costs.
Right.
Not every attorney does that. So you want to make sure you're, checking that with whoever that is. Typically, it takes about an hour to get everything signed and funded. Usually about 20 to 30 minutes of signing,
Right.
and then maybe 20 to 30 minutes of getting everything funded, documents to the lender, and all of that kind of thing. Which means the funding, when I say that, that means the lender is giving me permission to hand out their money. So
Mm-hmm.
I have their money, but I have to have their permission to then pay the seller and pay the agents and pay my fees and all of that. So that's what we're waiting on. So usually about an hour in my office is all we typically need. Sometimes a
Right.
little longer, sometimes a little shorter. Depends.
Okay. Now, with wire fraud being such a big thing right about now, how would you be requesting funds from a buyer or seller who has to bring money to the closing?
Yeah, we are very, very particular about how we both send our instructions and also how we get that. So, most sellers are walking away with money and they may want us to send them a wire. So
Mm-hmm.
we collect that information from them, but we always make them authorize that in person. So if
Mm-hmm.
I've received wiring instructions from a seller, they've signed off on them in person, and then somebody calls me or emails me and says, hey, I want to change it. We're not going to accept that. The only way you can change your wiring instructions is if you come back to my office with your ID, prove
Mm-hmm.
who you are again, and then change it in person. Because we're not going to do that, because that's what people do. As far as hours go, we're going to send that to you via secure portal. So we have a new online secure portal actually that all of our clients and our agents get access to. You get all of your stuff for the closing in that portal. So you log in. I know it's another login, but it is what it is these days. But you get that one invite from us, and then once you go back in, you log in. We can send you messages through there. You can send us messages. You can
Right.
send us documents. We publish documents to you. Ours, I call it like the pizza tracker of closings. You'll even see on there, it'll have a little tracker and it'll show you where the closing is. Like, have we submitted title to the lender? Are we scheduled yet? It'll show you all that little stuff. So you kind of get a feel for where we are with your closing, which is really nice. And it's all behind that secure portal and wall. So that way you don't have to worry about anything. And we're only going to send you stuff in there. So if you get another email that's not secure that says, oh, hey, here, send your money here, don't do it. That's what we tell. We're only going to send it through secure email. We also even put in there, please call us when you're at the bank or initiating your wire. We'll double check and make sure you're sending it to the right place.
Right.
Don't ever call on that email. If you get an email that says, we've changed our wiring instructions, please call this number to verify. Well, obviously they're going to send you to wherever they want you to call. So always call the number that you already know is mine or we already know is yours, to do that. So we just try to remind people of the good practices and also remind you that we're only going to send it to you via secure portal so that you don't have to worry about anything else.
Good. As far as the 4%, tell us a little bit about the 4% tax versus the 6%, primary resident versus your rental property. Why is that so important to know?
Yes, huge thing. And we talk about this at our closing. So anytime, so South Carolina state law says that our property tax rate is at a 6% rate. And so that means they take the value, they multiply it times 6%. That's how they get the assessed value. That assessed value is then multiplied by a millage rate. So each tax district, county, city, whatever district you're in, has a millage rate, and that's how they get your tax bill. So the 4% and 6% is done at the front. So if it starts at 6, but there's an exception, right? So if it's your primary residence, so it's where you live, it's what's on your driver's license, your name is on all the utility bills, it's on your tax return, and they're going to ask you to prove all of that. So you're going to have all that documentation. You submit them an application with all that documentation to prove you live there. They'll reduce that down to 4%. A lot of people, that doesn't sound like a big difference, right? 6 to 4%.
It is.
It's a huge difference. And their reason is because the 4 and 6 is done up front. Like I said, it's done at the very beginning and then multiplied by the millage rate. But then there also are these credits that are given if it's your primary residence. So you do the 4%, and then you also get these credits on your tax bill. So if anybody lives in a home, you could pull out your tax bill and you would see school tax credit, these other credits, there's a sales tax credit. There's all these different credits that get on there. So by the time you get down to your bottom line, to go from 4 to 6, it always doubles. In a lot of instances, it triples the tax bill. So depending on where you are, it will potentially triple the tax bill, which of course is a huge number. So that could take, let's say you had a $1,200 tax bill, that's $100 a month in your mortgage payment, right? If that triples, now that's $300 a month in your mortgage payment. That is a huge jump for people. And it's all because they probably didn't after you buy the property to show you live there, have all that documentation to prove it, and get that at that lower tax rate. And that 6% is going to be on any additional property you own. So it doesn't necessarily have to be investment. That could just be a second home that you own at the beach or at the lake. That's going to be taxed at that 6% rate because the 4% only applies to your primary residence, which of course can only be one property.
Right. And I think the standard rule to apply for that 4% tax is one at the county office in about 30 days after you've closed on your property.
Yeah, I usually recommend 30 days. The county needs time to get the deed processed and know you're the new owner. So for my clients, I send them home with a paper copy of that application. I will say Dorchester and Berkeley both accept this application online now, which is awesome. So you don't even have to go to the office anymore. You can do it all online, upload your documents, but I still send the client home with the application in paper just as a reminder to not forget to do it.
Right.
And then, yeah, wait about 30 days and then get it done.
Okay. All right, Summer, with now that things have changed a bit with COVID, I know we're in an interesting situation right now where, you know, we can go from beginning to end and not even physically see our client. Does a client have to show up in person like we used to do to get a property closed? And if not, what is the process for getting that done?
Yeah, so, all right. So right now in South Carolina, there is no authorized legal way to do online notarization. So even though you and I are on this call together and I know it's you and you know it's me, you couldn't sign a form where you are and then me notarize it where I am. That's not legal in South Carolina. So in the traditional transaction, both buyer and seller have documents that have to be notarized. So that means they do have to come see me in person. However, we do have lots of things that we are doing to work with clients who are either high risk or nervous or just to keep everybody safe, obviously. I will say a lot of people are still coming into the office. We, of course, sanitize in between each transaction. I wear a mask. We all wear a mask during the transactions. We get new pins out of the box each time. And I always sanitize the pins before I walk in, even though I pulled them out of the box new, just in case. So we do things like that. We also do offer curbside closings. It takes a little bit of work to make sure everybody feels comfortable. And of course, like it can be a little daunting to sign 80 pages in your car. We've done that before and we can make that happen. I've even done a closing in the person's house. If they're more comfortable doing that, like us going to them, or there are some remote notaries that I can send to there. They do cost extra, of course, because that's an additional service that's provided to send someone outside to their office. But we've done that before. So there are things that we can do to make everybody feel comfortable, but unfortunately, the way the laws are written right now, there is still that personal link that does have to be made in at least a minimal, facet. So whether that's you drive up in the car and I bring you the docs and I see your ID and I make sure, and then we can do the rest through Zoom, and then I pick the documents back up from you. You know, we can work things out like that, but we
Right.
do have to still have that personal touch at the moment. They are working on a law to allow online notarization, but it's not in effect yet.
Yeah, I know everybody's having to be creative these days, hence
Yeah.
the reason for this video.
Right.
Yeah. So Summer, tell us about the taxes and insurance. We know that South Carolina is one of those states where your taxes and your insurance is included in your mortgage. Why is that so? What is the purpose of that?
Yeah, so that's going to be in your escrow account. And generally that's from the lender perspective. So the lender, and it's going to depend on the lender. Let's say you didn't want to escrow, you would have to talk with your lender about what their requirements are to waive that escrow requirement. Typically, you're going to need at least 20% down on that, maybe even more. I know some lenders require 40 or 50% down. And ultimately, it's for their protection, right? They're looking at it as, you know, we're loaning you all this money on a house. If you don't pay the taxes, you're going to lose it in a tax sale. If you don't pay the insurance and it burns down or some damage or a hurricane comes through, like that's our money on the line. It's not necessarily your money as the buyer if you didn't put down 20 or 30%. So if you're getting a larger loan, they're looking at it as a protection on them. So they're going to require you to put that in an escrow account. But I mean, it's, to me, it's not a bad thing, right?
It's not.
It's your money. It's always your money. It's a
Yeah.
savings account for you that the lender is just holding on to. So they just, you know, you pay $1,200 a year for taxes. They're going to make you pay $100 a month, and they're going to put it into that account. And then when that tax bill comes out at $1,200, they're going to write a check out of that account to the county tax office. So you don't have to write the check. It's already budgeted for you, right? They are doing that kind of budgeting for you. And like I said, it's always your money. So if you pay off the loan, you refinance, you sell the property, whatever money is in that account is going to come back to you. So it's a savings account for you that the lender just holds on to.
Summer, this was good. I know that there's a lot more on our, list that I kind of wanted to get into, but
Yeah.
I want you to tell us a little bit about other services that you might offer other than just closing on a home.
Yeah. So, I mean, our main process or what we do is real estate closings. We do also offer some estate planning. We do wills and healthcare power of attorney, things like that. We kind of keep it to the simple ones, to do that, but we do offer that for clients. One thing that we help out with a lot too on agents is, I mean, while yes, we do the closings, but we help you get to that process too. So if you have questions with how you need to word something on a deed or a contract, we'll help you with that addendum language that you need. We do deeds as well, deed transfer. So like I've got one now where he's transferring some property to his kids. So I'm working on those deeds and drafting that up to transfer over to his kids. We can even add deed restrictions in those. So, you can't restrict everything, but there's certain things that you can provide restriction for to kind of just stop, certain things from happening on the property. So we can help with that stuff as well. So most of our stuff revolves around the real estate side of things, but the wills and the healthcare power of attorney, living wills, that standard probate package that everybody really needs to make sure they have, we offer that service as well.
Awesome. Summer, this was good. Hopefully we can come back and do another one. There's some other things that I want to get into, things like heirs property, the homestead exemption. I know there were a few other things on our list that we wanted to kind of get into, but I know it would definitely take more than the time that we have today to talk about that. But I do want to thank you so much for coming on, and hopefully we'll see each other again shortly.
Sounds good. Thanks so much for having me. I do appreciate it.
Thank you, Summer. All right.